In today's episode of Joe the Lawyer, we're going to discuss the dissenting opinion in District of Columbia v. Heller. District of Columbia v. Heller is the seminal Second Amendment Supreme Court case in the United States. In a prior video, I went into detail about the majority opinion in District of Columbia v. Heller. Today, we're going to talk about the dissent. Hello, everybody. Thank you for joining us today. My name is Joe Pometto, Joe the Lawyer. If you like this show, do me a favor. Please subscribe, like, comment, and share. It's a free way to support the show. It lets me know people are watching. It also lets YouTube know that people are watching and gives me higher rankings in turn. Also, sign up for my email list. There's a sign up in the description below. You'll get a free PDF on what to do when stopped by the police. So let's talk about District of Columbia v. Heller and the dissent. The reason I want to talk about the dissent and the case in the first place was because DOC v. Heller is the opinion that lays out the entire framework for the Second Amendment when it comes to constitutional law. And I went over that in the last video, but let's do a brief synopsis here. DOC v. Heller involved a case where the District of Columbia had passed a law that basically banned firearms entirely, did not allow individuals to have firearms in their home even for self-protection. The plaintiff in that case was a police officer who was trained in a weapon, who wanted to keep a weapon in his house, a handgun in his house, even if he wanted it dismantled, he wanted a handgun in his house. The law forbade it. So he took the case to the Supreme Court, and the Supreme Court, in the majority opinion, held that the Second Amendment does protect an individual's right to have a handgun in their home. This was a huge opinion. It just came out in 2008. I was surprised that no language on this had existed before in prior Supreme Court cases. But this case, the majority opinion protected the right of the individual to have a handgun in the home. Some interesting points about the majority opinion is that it appeared to make a total ban on handgun possession in the home unconstitutional. So state legislatures and or the federal government could not write laws along those lines. However, it appeared to allow licensing requirements to be constitutional, okay? And some even believe that it appeared to allow Congress or state legislatures to do bans on concealed carry in public places. So it allows state legislatures and the federal government to regulate the carrying of firearms in public places. Finally, it appeared to allow the state legislature or Congress to ban dangerous and unusual weapons, so things outside of a rifle or a handgun. We're talking a bazooka or a rocket launcher. However, where does an AR-15 fall? Maybe somewhere in the middle. We will see in the future as the law develops. So that was the holding of District of Columbia v. Heller. Now I want to go into the dissent. The reason the dissent is important is, well, first of all, what is a dissent in a legal opinion? So when in the Supreme Court, for example, you have 9 justices. If 5 justices agree, then they'll make a decision, and their decision will become the new law of the land. And what attorneys have to do is read that opinion to pull out the specific rules, and that will be the law as it is applied in the future. Well, those 4 other justices who voted the other way but were crowded out, they're allowed to write an opinion as well, stating why they disagree with the majority opinion. That is a dissent. Sometimes all 4 justices will join together and write a single dissent, or sometimes you will get separate dissents. And that is what you have in this case, District of Columbia v. Heller. They wrote 2 dissents, basically dissenting to it on 2 different types of legal grounds. We'll get into both of those. So the principal dissent was written by Justice Stevens, and it was joined by Justices Souter, Ginsburg, and Breyer. Justice Stevens, just to give you some background, he was appointed to the Supreme Court by Gerald Ford. His name is John Paul Stevens. And it's just a little bit of insight into the Supreme Court itself, right? This John Paul Stevens was appointed by a Republican in the 1970s. You would think that he would be a very pro Second Amendment type of justice, but it turned out he wasn't that way. The world changes over time. Justices change over time. John Paul Stevens was on the court for over 40 years. I believe he served until he was 90 years old. So as the world change and people change, sometimes the appointments to the court, those justices don't go the way people think that they will necessarily, even if they're appointed by a Democrat or appointed by a Republican. So Justice Stevens, appointed by a Republican, wrote the principal dissent to the opinion that upheld the Second Amendment right to have a gun in the home. Stevens reached a completely opposite conclusion from Antonin Scalia, who wrote the majority opinion, as to the purpose and intent of the Second Amendment. The amendment, he said, was adopted to protect the right of the people of each of the several states to maintain a well-regulated militia. It was a response to concerns that the power of Congress to disarm the state militias and create a national standing army posed an intolerable threat to the sovereignty of the several states. The framers had not evidenced the slightest interest in limiting any legislature's authority to regulate private civilian uses of firearms. So you can see here, Stevens, and this is something that you hear from talking heads or in the media all the time, that the Second Amendment was only meant to protect the rights of militias to bear arms. That's a principal liberal argument that comes from the left, and that's what he stood on in this opinion. Burden on the judiciary. Stevens then issued the kind of warning that in recent decades has usually been made by conservatives. I agree with this. That the majority's approach would encourage judicial activism. That approach will surely give rise to a far more active judicial role in making vitally important national policy decisions than was envisioned at any time in the 18th, 19th, and 20th centuries. So what Stevens is commenting on here is before District of Columbia versus Heller, the large majority of Second Amendment litigation that had gone to the Supreme Court only focused on militias, their ability to have arms, and whether and what happened was over the centuries is states developed into National Guard units. And as the National Guard became more organized and a bigger part of the state, there was question as to whether the Second Amendment only protected the right of the National Guard, the militias, to bear arms, or if it protected independent, non-National Guards militias. And if you look at the prior Second Amendment, and this isn't true wholesale, but if you look at a lot of the prior Second Amendment litigation in the Supreme Court, it just dealt with the right of militias to bear arms. So what Justice Stevens is saying is that the majority of the court went out on a limb here and broke from precedents. And oftentimes when you break from precedents, that's seen as judicial activism, it's seen as judges trying to make new law instead of just interpreting based on precedent and the language of the Constitution. Usually, it's the conservatives in politics and the conservatives on the court who say that the liberals are the one breaking from precedents, going outside of the normal bounds of judicial decisions to come to a decision that they want to make. They're seen as judicial activists. Roe v. Wade is a principal case in this flavor. So Justice Stevens is using a common conservative argument against them, which is very persuasive, calling out their hypocrisy. It's a good way to sort of attack another individual's argument, is saying, look, you rail about this all the time, and now you're doing it. So that was the principal dissent and the principal argument behind Justice Stevens. There was a further dissent written by Justice Breyer, joined by Stevens, Ginsburg, and Souter. he agreed with Stevens' argument that the Second Amendment only protects militia-related, not self-defense-related interests. But he said even if the amendment were read to protect self-defense interests, the D.C. statute should not be found to violate the amendment. And then he went into what he believed the court should have taken on an interest balancing test, where the legislature should be allowed to pass laws if their interest, if the harm that they're trying to protect from is greater than the protection of the Constitution for that particular right. So if the legislature could prove that their law reduced the amount of gun killings or reduced violence, then that was a social good that outweighed an individual's infringement on their rights. He said that should have been the test that was applied, and under that test, the law should have been upheld. He also said that the justices, come on now, should give deference to the legislature in issues of policy such as this, as they have more information and resources at their hands to determine what is the best decision to make. That's a very common argument. As far as the interest balancing test, I can't remember exactly, but the majority sort of leaned away from that and basically said that it's an absolute right, that it's sort of black and white when the right has been infringed in this particular case, and it shouldn't be an interest balancing test. So another interesting way to attack Scalia and the conservative majority's decision protecting the individual right to bear arms in the home. I thought Stevens' dissent was more persuasive, but Breyer's dissent definitely adds something to the argument. So why is this relevant today? Well, as I talked about in my last video, I think we're going to see, we are going to see in the future, especially when it comes to states regulating the right to bear arms, I think we're going to see some of these arguments fleshed out at the Supreme Court or at lower courts. And if you listen to the arguments here, the arguments used by the dissent are probably going to be the arguments that are used by liberals when they try to justify their ability to pass laws regulating the right to bear arms. And if you watch the news or if you read articles where commentators are quoted on Second Amendment arguments, you're going to find, you could read this opinion and you're going to find the arguments that they're going to use, or you'll find better arguments, than they will ever use, than you will see generally from commentators or talking heads on the news. So, the lines here are pretty clear. The conservatives read the Second Amendment to encompass more than the right to bear arms of a militia, more than just a militia. And what they're doing is sort of expanding the definition of a militia. Militia is a broad word. But there are parts of the Second Amendment as well that appear to allude towards personal usage of guns. And the liberals just say, no. The fact that militia is in there means that it only means a militia. So I wanted to highlight the dissent here and the arguments. This will give you a better understanding of Second Amendment rights going forward. In my next video, I'm going to discuss what happened in Virginia. Some laws were recently passed in Virginia regulating the Second Amendment right to bear arms. I'm going to let you know what I think about whether those laws are constitutional and whether constitutional challenges to them will end up before the Supreme Court. So thank you for tuning in to Joe the Lawyer. I hope you learned something today. Watch this video in conjunction with my prior video on DC v. Heller, and watch my next video to get my opinion on what happened in Virginia. If you like my content, please like, subscribe, comment, and share. I'd really like to get to 1,000 subscribers. I have over 500 right now, so shoot me a subscribe. It lets YouTube know that you're watching me, and if you get me to 1,000, I can monetize this channel. Also, sign up for my email list. You get a free PDF, What to Do When Encountered by the Police, just for signing up. Thank you.